Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me today is Senior Associate at MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thank you. Sam, this was your idea. The topic for this episode was your idea. We were talking about some of the consults that you've been having lately, and I guess you had some HOA members, some property owners come in and talk to you about some of the tenants that they had. Mm-hmm. And so when we were chatting about it at lunch, you thought it might make a good episode. I looked into it a bit and started to think about it and said, yeah, I think we could build an episode.
This comes up all the time. You know, that dynamic between homeowners or members and their residents or tenants, to be precise. And this also creates a number of precarious situations for HOA boards. So I think this makes a good topic. Hopefully it has value to our viewers and listeners.
Right. So let me start. So today, we've talked about what we're going to talk about. The topic today is basically the difference between a tenant, the rights of a tenant vis-a-vis the HOA, and the rights regarding what they're allowed to do within the community, and an owner, an HOA member.
Yep.
Okay, that's the main topic today. Because obviously, tenants have rights, members have rights, and there are some things that tenants can do that members can't do. We're going to talk about that. But before we get to that, I want to kind of lay out a foundational issue to talk about the concept of tenants first, okay? So, obviously, if you own a piece of property and you don't live there and you want to rent it out to somebody else under a lease, and they pay you, and, even though you live somewhere else, you collect this money and you still own the property, but they live there, that makes them a tenant, right? HOAs in California can exert control over tenancy as a concept or a topic in their communities. But California law, specifically the Davis-Sterling Act, has placed limitations on that. So I want to briefly touch on those just for context, and then we'll move on, okay? In California, an HOA cannot outright ban a homeowner or homeowners from renting to tenants if the lease term or the tenancy term is longer than 30 days, okay? So in other words, they can't outright ban, you from renting your property out if you want to go from year to year, let's say, with a tenant, okay? They can, however, place limitations on that, and one of those limitations is an HOA can say, okay, we don't want our community becoming a renter's community where the majority of people in our community are renters and not owners. So we're going to limit the percentage of homes in our community that can be rented out at any given time. They can do that. The law says that they can't go below a minimum of 25%. But as long as they're within that minimum, they can say, for example, okay, at any given time, only 25% of our properties in our community can be rented out. Meaning if your HOA has 100 properties, they can say no more than 25 can be rentals at a time, but they can't go below that, okay? That's one of the major controls. HOA, and we'll talk a little bit later today about a few other things HOAs can do. For example, HOAs can require that you provide them with copies of the lease, right? Stuff like that, okay. Now, what HOAs can still do under California law and under the Davis-Sterling Act is they can say, we don't want short-term rentals. A short-term rental is defined as any term under 30 days. So that's typically what people think about when you think about a short-term rental. 3 days, 5 days, a week, 2 weeks. HOAs can ban that, okay? Outright. They can just say, not at all, okay? If the governing documents don't say that, then you have a right as a homeowner to engage in any kind of rentals you want. But if the governing documents do say it, and they said it when you bought, that's the big one, then the limitation applies to you. That grandfathering is important in California because if you let's say you bought your property 10 years ago, and tomorrow a new rule went into effect that said no short-term rentals, that is no 1 week rentals. You can't be on Airbnb. But you bought 10 years ago. Until you sell that property, that new rule doesn't apply to you. You can have all the short-term rentals you want, and the HOA can't stop you. But a new homeowner coming in, they can. Okay? All right. So that's it for the main aspects of the law. Now let's get to the nitty-gritty here. Okay? On the surface, it seems like anybody that lives in a community would have the same rights and responsibilities. But I think most of our listeners who have listened to at least half of our podcast would now know, no, that's not the case. And they could probably list off a few of the things they can't do. Probably. So we're going to go and list off those obvious things. What are some of those obvious things? Because this distinction, Sam, it matters, right? it affects a lot of things that go on in an HOA. Give me some of the big things that a tenant can't do.
Well, one of the key things, a tenant cannot participate in elections, whether it's voting, running for a board position. They don't have some of the same rights in terms of, let's say, requesting or demanding documents and records from the association.
So let's break that down for a minute,
Yeah.
and then go on with your list.
Sure.
They can't run for the board. They can't sit on the board.
Correct.
That's state law. It doesn't matter what the governing documents say, by the way. Governing documents could say anybody can sit on the board. Well, that's not true, because the law actually says you have to be a member. So tenants can't sit on the board. They can't run for the board. They can't vote at all.
Yeah.
And they can't demand documents under the provision we've talked about in multiple episodes, Civil Code 5200.
Yep.
They don't have a right to that. Okay.
That's a biggie, yeah. Well, the other thing they can't do is along the same lines, they can't participate or initiate a recall of the board members.
Of course.
So
they can't sign a recall petition.
can't
Well,
sign
they
it?
can, but it won't be counted.
It'll be invalidated, set aside, easy.
Yeah. They can sign it if they want.
They can request special meetings. They cannot request, let's say, IDR or various types of, participate in, let's say, disciplinary hearings. I mean, typically that's reserved to the homeowners.
Actually, it's two-sided. The HOA can't call a tenant to a disciplinary hearing.
That's exactly right.
If a tenant does something really bad, the HOA will call the homeowner, the landlord, to the disciplinary hearing because that tenant, anything that tenant does is on the landlord.
Right. And that's really the locus of enforcement against the homeowner.
Exactly.
Yeah.
So there you go. You heard it from the horse's mouth. Okay? They can't do any of those things. They don't get to participate in the running or management of the HOA like a homeowner does.
Yeah.
Okay? Now, what can a tenant do? Well, tenants can use the amenities and the facilities.
Right.
In fact, the law states that the HOAs can't bar them from using it. If there's a community pool, a tenant, as long as it's a valid tenant and not in violation, for example, if it's a short-term tenancy, this person's here on an Airbnb, and that HOA already has no short-term tenancies, they could ban them because they're not really a proper tenant. Okay, but if they're a proper tenant, they can't ban them from using that pool or the pickleball courts or the tennis courts or the gym, or using the guard gated community, or if there's a doorman or concierge, or depending if you're like in a high-rise condo, they can't stop them from any of those normal amenities.
Yeah.
Now, interesting fact, there is case law interpreting the Davis-Sterling Act which supports the following proposition. To the extent that a member, the owner of the property, has tenants there in the property, those tenants have a right to use all those amenities. But an HOA can have a rule that says, okay, if you have a tenant, they can use all that stuff, but you, the non-resident member, you can't. You don't get to use it. So if you were to come visit the property, you couldn't go and use the gym while you were there. If your HOA has a rule requiring that only residents can use those facilities, they could actually ban a non-resident member of the HOA from using it while there's a tenant there. And the reason is simple, or the reasoning behind that is pretty simple. The impact and numbers. We anticipated or contemplated X number of people. Well, now you have tenancies that kind of multiplies that. So they say, no, tenant steps in your shoes as the owner's shoes.
It speaks to capacity, wear and tear, degradation of those components.
So the tenant will step in the shoes of the owner when it comes to amenities.
Yeah.
Now, of course, that's not the default rule. That has to be in the documents. But an HOA could pass a rule that says only residents. Now, residents includes owners and tenants. It's anybody who resides. If you reside in Southern California and you've got a rental in, Northern California and you don't reside there, you're not a resident, your tenant is. Okay? Now, the argument becomes a little more muddy if the unit's empty. You don't have a tenant there, then it becomes a little more muddy because the whole reasoning, remember, rules have to be reasonable. The whole reasoning behind that isn't serviced.
Right.
So that's an issue for another day. Okay? All right, so let's do the flip side. I'll handle that. You handle, what is a tenant, basically? What's a tenant? And by the way, let's mention this. A tenant is not a guest. A tenant is not a squatter. A tenant is not an invitee, like your plumber or contractor.
Like a contractor doing work on your property. Right.
A tenant is a tenant. And in order to be considered a tenant, a few requirements are typical. Okay, there's going to be an oral or written lease. Some HOAs require a written lease because they want a copy of it. You can't get a copy of an oral lease. So if your HOA has that requirement, then you got to abide by it. But aside from that, it is some sort of agreement for use, and usually there's payment involved. Right?
Right.
Okay. A family member can be a tenant if you own a unit. We have this all the time. You own, let's say we've seen this. I'll give you an example of one of our clients. Our client lives in Newport Beach. Their daughter goes to UC Irvine. They bought a condominium near Irvine that they rent to their daughter. Now, their daughter doesn't pay rent, but there's a lease, okay? And the lease is for $0 a month. But obviously, that daughter is going to be considered a tenant for purposes of the Davis-Sterling Act. The daughter's a tenant, okay?
Right.
Unless they put the daughter on title, which does happen sometimes, and then the daughter's an owner. Then the daughter can vote. We've talked about that before.
Right.
Even if, as long as it's recorded, you could be 1% ownership, makes them an owner, okay? So there you go. So what is an HOA member? Well, it's the flip side of what Sam said.
Yeah.
Okay, HOA members can vote. HOA members can run and be elected to the board. It doesn't matter if they live there or not. That's irrelevant. In fact, we talked in a recent podcast about a situation where there was a 55 and older community.
Yeah.
And this individual who was 21 years old, or 20 years old, grandparents died and left the property to their grandson.
Yeah.
Now the grandson is not allowed to live there because the grandson was 33 years too young, right? It was a 55 and older community.
Right.
But the grandson could vote. The grandson could run for election on the board and win and serve on the board, even though they can't live there and never can till they turn 55.
Right.
Okay?
And this is basically, in other words, someone who has legal title to their property.
Right, exactly.
Individuals, married couples, could be a trust, could be
Right.
even a corporation or LLC.
That's right. So an HOA member is an owner, okay? Owners can vote. Owners can run for the board. Owners can sit on the board. Owners can sign a petition. Now, when we did a recall petition episode, and we were very careful to explain that if there's, let's say, a husband and wife, two owners on a piece of property, for purposes of petition for recall, they only get one. They can both put their names down, but only get counted once, okay? So that still applies, but they can sign petitions. Their signature, or at least one of their signatures, will count. A member may call for a special meeting in certain circumstances. A member can be called to a disciplinary hearing, okay? Whether or not it's they directly did the wrong thing or it was somebody on their behalf, a guest or a tenant, it's not them that's going to be called to a hearing. It's going to be the owner. They can demand IDR. They can say, remember, if a homeowner, a member, demands IDR, the Davis-Sterling Act obligates the HOA to participate and provide at least one director willing to sit down and talk. Tenants can't do that, as he said, but members have the right to demand it, and members, very importantly, have the right to demand a whole host of documents under Civil Code 5200. We've had at least one podcast. No, we've had two episodes, one short, one long, on 5200 alone, and there is at least one pretty spectacularly complete article on my website, mbkchapman.com. I say that because I list a bunch of documents that you can demand and the legal basis for them in case you ever wanted to use them. So I actually made it real easy for you to make that demand. But anyway, these are things members can do that tenants can't.
Right.
Okay? So those are the basics, okay? There's a big difference between them. And remember, members, while they're living at the community, can use all the facilities like everybody else unless they've been disciplined in a properly noticed hearing and they've been banned. But other than that, they can use them as long as they're living there. But if the HOA does have a rule in place that says only residents and they are renting out and not living there, then a member can actually be stopped from using the pool. Okay? And so, like I said, it's the flip side, right? Now, let's talk about a tenant. We talked for a minute about the one of the primary things that tell you somebody's a tenant, right? Aside from the fact they're not an owner, but they happen to be living there.
Right.
But they could be a squatter. They could be a guest. So what differentiates? Well, usually there's a lease of some sort. Whether it's oral or written, there's a lease, okay? So a tenant's, so I want to say that a tenant's rights to use the community come out of one of two places, okay? Or both, okay? Either a lease or rental agreement, oral or written, with the landlord, the owner of the property, or out of the governing documents of the association.
Yeah.
So let's talk about the first one. Very brief. We already covered it a little bit. A lease is an agreement. It's a contract between an owner and a renter that says, here are the terms that I'm going to let you live in my property. And then it can be a formal lease, which has all the normal things in it, to a piece of paper that says, you pay me, $1,500 a month and I'll let you live there.
Mm-hmm.
Okay? It could be that. Okay? Or it could be oral, as long as it covers kind of those things. Okay? But by virtue of that tenancy, assuming that the HOA doesn't require a written lease or anything, let's say your HOA is one of the ones that doesn't need a copy of it, okay? Then by virtue of that oral or written agreement, tenancy, the tenant now has certain rights. They have the right to come in and out, ingress and egress, to park in the community wherever owners are allowed to park. Mm-hmm. And they have a right to use the stuff, whatever it is. If it's private roads, you have a right to drive on the private roads. If it's private green belts and walkways, you have a right to walk on the private green belts and driveways. Mm-hmm. They have the right to use the common areas. If there's a little park, they have a right to use the park in the manner in which it's designed. Mm-hmm. And they have a right to use the gym, the pool, pickleball courts, tennis courts, clubhouse, whatever it is. Okay? Mm-hmm. Now, when it comes from the governing documents, that's when a board or an HOA can say, okay, tenancies are allowed, but we want to see a copy of a lease. And if it's modified, we need to receive any updates, right? Mm-hmm, mm-hmm. What they can't say is, oh, and we're going to do the credit check to make sure that they are. Yeah. Because it's not relevant to them. They don't pay. Right. Tenants don't pay HOA assessments.
They don't have contractual privity with that tenant. Yeah.
Tenants don't pay any assessments. Owners do. If the HOA assesses a huge special assessment, $20,000 special assessment, fixed balconies, okay? The tenant's not paying for that. The landlord's paying for it. Yeah. So the HOA has no business asking for financials. Mm-hmm. Well, we only want a certain quality of person living. Well, it's not their business, okay? Just like the HOA can't invent rules that would otherwise violate federal or state discrimination laws.
Absolutely.
Okay, can't do that.
Fair housing laws, all of that.
Right, exactly. Okay, so the tenant can't, or the landlord can't, the HOA can't say, we, in addition to wanting a copy of your lease, we want to be able to vet whether this person will fit in or be a good tenant. It's not their business. That's between the landlord, you, the owner, and your prospective tenant. That's it. HOA can't do that, okay? HOA can't require that a deposit be made to the HOA in case the tenant causes damage or a problem. No. Mm-hmm. If the tenant damages the common area, the HOA will skedaddle right over to the landlord, the owner, and say, pay. Yeah. And then it's between the landlord and the tenant to say, okay, I just had to pay $1,000 to fix something that your kid tagged the stop signs in our neighborhood, which were owned by our HOA. So I paid $1,000 to have those repainted. You owe me $1,000 on top of your rent next month. Mm-hmm. That's between them. That's between you and your tenant. It has nothing to do with the HOA. So they can't require a security deposit or anything like that. Right. Okay? That doesn't stop some HOAs from trying, though, does it, Sam?
It does not, no. Okay. Yeah.
So let's talk about the common disputes, because this is where you see this all the time. Mm-hmm. Common disputes that arise between HOA members and tenants who live in HOA governed communities. Mm-hmm. Because remember, and courts have even recognized this, and then I'm going to let you take the first couple, okay? But courts have recognized this. They've said this directly in some court cases, okay? Tenants don't have the same interest, financial or otherwise, in ensuring that the common areas of the properties are well taken care of. They don't have a stake. Mm-hmm. And so, by definition, they can very well be apt to not care as much. Right. And in recognizing that reality, right? When you don't have a vested financial interest in something, you're not going to take as good care of it.
And they could be the most conscientious, caring people otherwise. But if you don't have, let's say, legal title to the property and you don't care about possible impact on the property values.
Future assessments.
Right. Yeah.
It's just courts have recognized the fact that a non-owner isn't going to have a financial vested interest in taking care of the common areas and the long-term health of the association, because they don't have any real connection other than a temporary tenancy, typically a year, even though they can renew it year to year, but still, that's what we're talking about. So there is this constant tugging and pulling and tension between owners and tenants, because tenants are often at the root cause of problems. So let's talk about some of the most common problems that form the basis of conflicts between members on the one hand, and members at large, not necessarily just you, the landlord. You don't live there, so it's probably not going to even affect your life directly at first. We're talking about other members. What are some of the big ones?
Well, the biggest one that comes to mind is really nuisance complaints. And these are noise nuisances.
Yeah, so nuisance is a broad term. Let's break it down. I want to be specific.
Yeah.
So let's talk about other nuisances later. I want specifics. Okay. Noise. Talk to me about
noise. This could be, let's say, in stacked living arrangements, right? Condominiums, usually. Disputes over, let's say, your upstairs neighbor who could be a tenant, and the lower unit neighbor could be a homeowner.
What's happening?
Hardwood flooring, and they're being loud. They're being extremely loud.
So stomping around. Dance practice.
Dropping weights, etc. And that leads to a protracted dispute usually, and the HOA is dragged in.
So that's a multi-unit thing. You got to, let's say there's no rule against the wood flooring, but this other person makes a habit of practicing Irish step dancing, let's say, okay? Which is loud. Okay, if you've ever watched, it's very beautiful to watch, but if you're below a unit that does that, it's loud, right? Or let's say they play their music, or they've got a band and they practice guitar at 10 o'clock at night, really loudly, okay?
Or multiple parties at all times.
And that could be anywhere. You're in a single family dwelling neighborhood, and you got a tenant next door who has a party every single Saturday night that goes till midnight, even though quiet time starts at 10. Just abusive use or making of noise, which interferes with the quiet enjoyment of other people, okay?
Right.
From the member's side, the neighbor that's suffering from that noise has two ways to go about doing this, okay? The other member, the member that's being victimized by the noise, that is your neighbor or your, you don't live there, so it's not your neighbor, but the person who lives next to your property has a claim directly against the tenants in law under nuisance provisions.
Right.
The tenant can't sue for violating the nuisance provision of the CC&Rs, because the tenant is not a party to the CC&Rs in that contract, but they can sue under state nuisance laws, which are covered in the civil code.
Private nuisances, yeah.
Right, so they can sue for that, okay? And the tenant can go after you, the member, landlord, for failing, assuming that they've attempted to have you address it and you have failed to do that. They can go after you for empowering or not stopping the nuisance, and they can do that under both the civil code nuisance provision, but also under the CC&Rs nuisance provisions. So basically a victimized neighbor who is unhappy with a tenant can sue the tenant and you, the landlord, for that same thing, provided that they can prove that you were aware of the issue and didn't stop it. If you have a new tenant move in and you've never heard hide nor hair from anybody, they're not going to be able to successfully sue you for any sort of negligence because nobody made you aware of it. But if you're aware of it, that's a problem. They could even, depending on how serious the tort is, if we get into, we'll get into that in a minute. We'll get into that when we hit into the more serious things. So noise is one of the big ones. We hear that all the time, okay? I'll handle the next one, and then you handle gym and clubhouse behavior, okay?
Okay.
Parking and vehicle misuse. That could be a lot of things.
Yeah.
Speeding. If your neighborhood, like mine, has a speed limit, okay? In my neighborhood, it's 17 miles an hour. I don't know where they got that, not 15, not 20, but 17. If you're routinely speeding, you're going 50, 55 in your neighborhood, you could be disciplined for that, if you remember. And if your tenant is doing that, you'll probably hear from the board, but other members, other people that live there who have their kids playing in the street, let's say, who've yelled at this tenant, slow down, slow down. If there's an issue there and it's not addressed, it doesn't have to come from the HOA. That other member can go after you, the owner, the landlord, okay? They can, if they feel confident in being able to prove that the speeding is considered a nuisance, they could go after the tenant under the same theory we just talked about with noise, okay? Yeah. So that's driving, vehicle misuse, okay? Or, for example, your tenant's driving a non-street legal motorcycle and your HOA's rules or CC&Rs happen to ban non-street legal motorcycles or dirt bikes. Again, those things are really loud, okay? They're often much louder, and those can be a nuisance in and of themselves, and at the very least, you could be in trouble for that, okay? So we see that all the time. Or, hey, this tenant's parking an RV. We don't have RVs in our community. They're banned. Who's going to get in trouble?
I just had that issue a few days ago.
Both of you going to get in trouble.
Yeah.
Okay. Under the same nuisance provision, the victimized, the complaining member can go after both. Those are the basics on that. Talk to me about pool or gym or
well, amenity in general, clubhouses, gyms, fitness centers, pools, pickleball courts. They usually have a set of rules. So in addition to what you may have in your CC&Rs, they usually have adopted set of rules for those amenities as far as usage, as far as hours of operation in terms of possible age limit, having...
Yeah, you can't be in the gym if you're under 12, let's say.
Right, or
without
having...
a parent.
Right, a guardian. And let's say a tenant, hypothetically, violates that, runs afoul of these rules. Or they may have, let's say, a 30-minute use limitation,
right.
and they totally ignore that at the prejudice of a member, let's say,
right.
in this
context.
Of anyone.
Another
really.
tenant.
And so that gives rise to disputes, right? Because now, okay.
And there, in that sort of,
give.
let's take that late thing you were talking about.
Okay.
Or having a 12-year-old in there when you can't be in there unless you're under 13 or older, let's without a parent. In that case, it would very few members are going to ever go after the tenant for that. They're just not. But the HOA can absolutely call you, the owner, into a hearing for violating a use rule. So you'll hear about it, and typically what you'll do is you'll tell your tenant, your 12-year-old needs to have the older brother or parent with them. Mm-hmm. Okay, you can't go in without. So please don't do that. It's usually pretty easy. It should be. If people are acting reasonably, this should be a no-brainer.
Right.
You talk to them. They might not have known, even though most landlords, and this is one of the issues that we run into, one of the problems, in addition to just tenants maybe not, just by definition of vested interest, not caring as much, it's not always the tenant's fault. Some landlords, a lot of landlords just don't give them the CC&Rs and the rules.
Yeah, that's true.
If they don't know what they are, they can't follow them. If they had no idea that people under 13 couldn't go and use the gym or the pool without supervision, then if they violate it, you can't really blame them for it. All right? It's only if you gave them that stuff, and a lot of landlords do, and all should. If you give it to them, and then they're on notice they should look at it, then if they violate, you can look to your tenant and go, hey, come on, man, it's right here, and write it.
Right.
But a lot of them don't, and that's a problem. That's one of the fixes is make sure that you give your tenants the copy of the rules.
Yep.
Okay?
That's exactly it. Yep.
Or at least that you put in some sort of letter to them saying, here are the things you need to know, and these are from the CC&Rs and the rules. And then at least you just tell them that. And maybe you don't give them the CC&Rs, but you tell them all the stuff they need to know. Either way works. But, yeah, that's not going to be one where you're going to see a lot of lawsuits between a member and a tenant.
No.
But you are going to see discipline from the HOA.
Yeah.
For that stuff. Yeah.
And the consequences could be dire. I mean, there are insurance consequences for the HOA, et cetera.
Exactly.
Yeah.
And now we talked about this already. I just will reiterate. You can't have a situation where only members can use the tennis courts, tenants can't.
Yeah.
That's not going to fly under California law. Just won't. Okay? That can't happen. But they can limit certain usage of certain amenities. Let's talk about the clubhouse for a minute. Tell me if you've seen this before. So you have a clubhouse, okay? And the HOA allows members to use the clubhouse for, let's say the clubhouse, a lot of clubhouses are fixed with a full kitchen, usually a commercial kitchen actually, and then, seating area and then whatever, okay? And some HOAs, maybe more along the more higher end HOAs, but these clubhouses can often be used as venues for a party or for, what do you call it, the dinner for the out-of-town guests of a wedding. What do you call that one that's before the wedding?
Oh, like, what do they call it?
It's blanking.
Not audition.
Rehearsal dinner.
Rehearsal dinner.
Yeah,
Yes.
So rehearsal dinner.
Yeah.
Okay, so and often it's free for use by the member, but they maybe have to put a $50 cleaning fee.
Yeah.
Okay. Under that specific scenario, an HOA can say only members can use the clubhouse for that particular purpose.
Yeah.
But for all other purposes, they can't stop them. If there's a weekly canasta, they can't stop them from participating in the canasta. Okay, stuff like that. All right. They and pool gym, they can enforce hours of operation, but they can't have special hours for tenants. Like they can't have members can go from 7 to 7, but tenants can only use it from 9 to 7. They can't do that.
No.
They can't do that.
Yeah.
They can impose a rule that applies to everybody, but they can't impose a rule that only applies to some and not others. Other than that one exception I just gave you.
Right.
Okay? Now, everything I just said goes out the window if the use that the tenant is putting the amenity through is a danger. Okay? If it's a threat to other people's safety or
Health, life, and safety, yeah.
or the safety of other people's property or even the association property, then they can ban a tenant outright. But they could do that with a member. So for example, this happened in a prior HOA I used to live in. There were some kids, 10, 11, 12-year-olds, who were routinely would climb over the gate after hours, would climb over the gate of the tennis courts that are locked, and then rollerblade and cause damage to the gate. They would sit on the net and do stuff that actually can be very expensive, right? The rollerblading left these skid marks all over, those wheel marks. Okay, this was a long time. These are the old wheels, but they were damaging common area. They could be banned. Their families could be banned from using it for a period of time. Okay, stuff like that. You can, or if you're doing something that is just a danger, it's threatening people's physical safety. Yeah, you can be banned. Okay, obviously, right? What's one? Let's step it up a notch. What's one that starts to get a little more serious? What have we seen? Tenants. Another thing that tenants can be accused of that can be a problematic. And members, don't get me wrong. It's not just tenants. Yeah. But right now we're talking about the dichotomy between the two. So what's another common issue between tenants and members? And I'm speaking about harassment.
My mind immediately went to civil harassment restraining orders, and that's harassment, right?
Violence,
I mean, when you have violence, threatening conduct, and this kind of speaks to that health, life, and safety somewhat, which is, they confront a tenant in this scenario would confront, let's say, another tenant or a member within the community, and oftentimes it's a part of a pattern of behavior, right? It's not an isolated incident.
Let's not just say harassment. Let's extend that. We see conflicts.
Yeah.
We see direct assault and battery occur.
Oh yeah.
Okay. If assault and battery occurs between two members, that's a civil issue. It's also an HOA issue under the nuisance provision that's very likely in the governing documents. Okay? But it's also a civil issue between the two. With a tenant and a member, if the tenant's the one committing the battery or the assault or both, it is civil and criminal. Just like I should add, it's criminal also, but it's civil and criminal. But it's not going to be an HOA issue between the HOA and the tenant. It's going to be an HOA issue between the HOA and the owner. Again, that's who's in privity. Okay.
Right.
So when it comes to serious things like harassment or assault and battery, in addition to getting the police involved, in addition to getting the tenant involved in the sense that a victim of that can go after you civilly and seek criminal prosecution.
Right.
The member can be held responsible. Now, tell me what if you can, what limitation there is on holding when can the owner be held reasonably liable? When would another member be pretty successful in going after an owner for the assault and battery committed by their tenant?
Well, let me address that. It's typically under the negligence theory, right? If they had notice of, let's say, prior misconduct of that nature.
That's the one.
Right? And they fail to take action. They fail to basically reprimand.
So give me a real life example of how that might play out. What happens?
Okay, let's say a tenant engages in acts that would constitute an assault, battery, acts of vandalism, property damage, and a neighbor, who's the victim in this case, let's say, complains to both the HOA and the homeowner directly. The landlord. The tenant, the landlord.
Not the tenant, the landlord.
The tenant's landlord, right?
Yes.
Like specifically of that tenant's landlord.
You, the member.
And this landlord, an absentee, offside, preoccupied, fails to take action, and repeated demands are made, right? Covers a course of, let's say, 6 months.
Like it doesn't even have to be 6 months, but basically, it's one thing if it's one complaint comes in, the landlord can say, look, I talked to them and they said they'd stop. But if it continues and you don't, if you're the owner, the member, and you don't evict,
hold them to account,
Yeah, if you don't evict that tenant on repeated acts,
right,
then you're going to be held liable under the standard he just brought up because you have notice.
By the way, the notice, usually the way this plays out normally is law enforcement is notified, the HOA is informed, the HOA sends the owner a notice.
Yeah.
So they have multiple avenues of notice, which kind of heightens that potential liability.
And they should be on notice about how serious it is because you have law enforcement often, or even if you don't, let's say nobody calls the police, you still have the landlord being contacted directly by the HOA because the tenant can make a complaint to the management company and say, look, can you guys send something? They often will do that, okay?
Right.
But if they don't, that's fine, because the other I'm sorry, I don't mean the tenant. The victim, who I'm assuming is another member, because we're talking about tenants versus members, that victim of the assault and battery, who's a member of the HOA, is going to go to their management company or their HOA and say, contact the owner and say that their tenant is threatening us and causing or battering us or assaulting us, and we need it to stop. So you're going to hear from that, even without the police. That's irrelevant.
Right.
And on top of that, it's very likely that as a member, let's say I was the victim, I would, if I didn't already know who the owner was and know where they actually live, I'd do a 5200 demand for their address, right?
Yeah.
And then I'd write to them directly and say, your tenant has done this, this, and this over a period of time, et cetera. It's caused all these problems. You need to evict them, or I'm going to come after you. Okay, let's say you, the landlord. Let's say it's your friend from, it's an old friend from high school who came out of the woodwork, and they're down their luck, and you rent them your unit, or you just, I don't believe they could ever be guilty of this. He's a nice person. And you ignore it and something happens, guess what? You were on notice and you could be held liable for negligence, negligent entrustment.
Yeah.
There's a bunch of causes of action.
Right.
And that could be some serious liability, very serious liability. So there's another major. That's right. Okay. It can run the gamut of any nuisance you can think of. And the more serious, the more serious. Right?
Dog bites in some cases, yeah.
Exactly. Oh, exactly.
Yeah.
Your tenant has a dangerous dog, not necessarily banned by the HOA, but has a dog that isn't under control and bites somebody. The tenant is going to be personally liable under the law, but the landlord, you, the member, can also be held liable if you were on notice that that dog presented a danger. Right. So after the first bite, you don't do anything to say, hey, if this happens again, I'm going to have to tell you to get rid of your dog, right? Or I'm going to evict you. You've got to keep that dog under control. And then it happens again, and you don't do anything, you're in trouble as an owner. You're in trouble because you're on notice that this dog's dangerous, and you didn't address it. Now, if you can show you did address it, like you were in the process of eviction, which can take months under California law. It's not supposed to, but it can.
Yeah.
Look at our courts. If you're in the process of eviction and it happens again, you're going to likely defeat any claim of negligent entrustment or failure to enforce, because you could show I'm actually trying.
Yeah.
It's not my fault.
Right.
So as long as you are acting, then you're probably safe from that, from the liability related to that issue. Okay. Yeah. That doesn't mean you're going to be safe from any civil fines that might occur or HOA fines. You might not be safe from those. So pretty much any nuisance obligations or a breach of the lease obligations, right?
Yeah.
If your tenant is violating parts of your lease that affect other people, those other people can hold you responsible for enforcing your own lease. Okay? Even if they don't necessarily know what the provisions of the lease are, they'll get them eventually if they file a lawsuit. But most leases that are written contain certain provisions, and if you're and if they believe that you are not enforcing your own lease against your own tenant, you can be held liable for that because of harm caused by your tenant. And so can the tenant be harmed directly, okay? And then, of course, property damage.
Yeah.
Tenant goes out, we talked about this. Tenant goes out, tags all the stop signs in the neighborhood, costs $1,500 to fix. Landlord's responsible. That's you. You're going to pay for it. Now, you'll go and turn around and demand it from your tenant, but if your tenant skips town and decides not to pay you, you don't have anybody to go ask. I mean, that's just the way it is. It's your responsibility. Yeah. They're there under your...
Just had a consult where a tenant backed into the exterior of a building, damaged the stucco, the exterior, big cracks.
It's just an accident.
$20-something $1,000 in damages. Yeah, it was major. It was severe.
So the landlord's responsible, and the landlord will turn to their insurance. Okay, and the landlord's insurance will probably hopefully pay for that. But yeah, the tenant is not directly responsible to the HOA for the $27,000. The landlord is, because they're the member. That's you. You're the owner. All right, I think we got them all, right?
I think we covered quite a bit, yeah.
Okay, so bottom line is there's a lot of tension in HOAs between tenants and members. They each have certain rights. As long as you kind of understand the foundation of those rights, you'll understand where responsibility lies. I think we covered that, okay? If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to our channel, HOA Hell. If you'd like to leave a comment, ask a question, make a suggestion, we love reading them. Please feel free to do that. And until next time, have a wonderful day.